Morning, everybody. Just got the last couple of people trickling in, and then I'll make a start. Happy April, by the way. Hope everybody's enjoying the good weather. Okay, I think we're just about there. It looks like everybody making their way in, so I will make a start, and obviously for my marketing team's purposes, we'll start from here. Good morning, everybody, and welcome to April already, and the first of 3 coffee break briefings between April, May and June that are going to be looking at the Employment Tribunal, how the Employment Tribunal operates as a court system, some practical experiences around procedure, process, how the tribunal actually works, and towards the end of the last session in June, a little bit on awards, appeals, what happens beyond the Employment Tribunal itself. Today's session, just to give you all a heads up before we really dive into this properly, is going to be a little bit shorter than usual. I say that, we all know how much I'll talk if I get going, but it is intended to be a little bit shorter than usual. 2 reasons for that. Firstly, it does need to be a slightly more introductory session than normal. I can't really do a series of 3 on the Employment Tribunal without talking about some real basics first. So those of you who are regulars to these sessions, there will be a little bit of repetition from previously, but that is because it's intended to be an overview of the Employment Tribunal and the kind of legal cases that are dealt with in the tribunal. The other reason, of course, is that I'm very conscious it's financial year end for a lot of people, and I'm sure most of you have got better things to be doing than listening to me talk at you for an hour about unfair dismissal and how the Employment Tribunal works. Our own financial year is the end of the next quarter, so I'm personally less concerned, but I do understand that it'll be a situation that most of you find yourselves in. So today's session, the Employment Tribunal, a little bit of an introduction. As always, please make use of the chat, the Q&A. I've got that available in front of me. I can see it if I press the right button. So if you've got any questions as we go, by all means ask them as always. The session is recorded. It will be made available to all attendees. They're also uploaded onto the Friends YouTube page after the session has completed. So if it's of interest to anybody else in your team and they've not been able to make it today, please do feel free to share once you've got access to that. Moving back just quickly to the topic of questions as we go, there may well be questions, of course, that come out of today that will form part of one of the next 2 sessions. If that's the case, then when the question crops up, I'll simply point that out and we'll make sure that it's addressed in either May or June's sessions. If I can answer it quickly today, then of course I will do so. Other than that, the only other thing to point out is we're deliberately running these 3 building up to an in-person event in June. We will be running a mock tribunal. Naturally, that will be down our way. So for those of you who are a little bit further afield than the South Coast, you may want to plan for that if you'd like to attend. Those of you who are closer, of course, we very much look forward to seeing somebody, you or somebody from your organisation there. Do save the date for that. I don't know how much marketing content has already gone out. I do know it's on the bottom of all of our email footers. So that will be, I believe, 18th of June off the top of my head. So moving on then, today's session, as I said, it will be a little bit of an overview session introducing the Employment Tribunal. Next month, we'll do a lot more on process, procedure, and what it's actually like being in a hearing. But I wanted to start today with a little bit of context. So it will be very overview, basics of employment law, the kind of claims that are dealt with in the Employment Tribunal. So we'll look at key areas of dispute and how they arise, situations where they do crop up. We'll look a little bit at the history of the Employment Tribunal, where it's come from. You'll probably get a little bit of a personal insight there as to why I enjoy practicing this area so much. Talk about some of the key legislation, the types of claims that arise, and then towards the end of this session, we'll have a little bit of a chat about the role of businesses, the role of managers, and the role of HR in trying to help mitigate risks and actually reducing the need to get to the tribunal in the first place. To be honest with you, as much as we all enjoy tribunal litigation, we are people who enjoy arguing. It's why you become a lawyer. When we're thinking about acting for you, particularly for respondent clients, it's not always the place we want to end up, and we would like to avoid you having to go to the Employment Tribunal. Of course, it's not a pleasant experience. For those of you who have been there will know. So, a little bit of an overview of the Employment Tribunal then, where it came from, what the background is. If we go far back enough, really, and I'm assuming most people on this call will not remember the industrial tribunals as they originally were. Some of us will still remember it from the terminology still being used in the 80s and 90s, and it's still the term used in Northern Ireland. But the industrial tribunal was originally set back way back in the 60s to tackle what I've said there, training levy assessments. That's the original purpose, and that's sort of the history of the employment tribunal. They had this very, very limited role that in today's terminology we would be thinking of as much more like arbitration. Two individuals sat down with a lawyer determining the outcome of what was in effect quite a basic assessment against some pretty simple criteria. And as I said there, originally chaired by a lawyer as a form of quasi-arbitration. It really was that simple with this quite limited jurisdiction. Of course, what happened in the 60s and 70s is the UK and indeed most of the rest of the world started to go through what is best thought of really is this kind of equality cycle. So in the UK, we see things being passed like Sex Discrimination Act, the Race Relations Act. Same-sex relations are legalised in the UK in 1966, implemented 67. And this all starts to build through the 60s and 70s. We start to see the concept of equal pay come into existence. And then, of course, rolling through the 80s and 90s, wider interpretation of discrimination and social acceptance of things beyond what used to be considered much more the air quotes norm. Then, of course, with EU membership later and the role that the European Union started to play in implementing directives that affected the workplace, it really did become the case that the workplace, that employment law in the UK was becoming increasingly complicated. The last major piece of legislation specifically in relation to workplaces we had, probably the 96 Employment Rights Act, and that introduced so much legislation that formed the basis of the Employment Tribunal becoming what it is today. So as I said on the bottom point there, it became the tribunal as we're familiar with it in the late 1990s, and the scope, the jurisdiction, the nature of the work did start to become a lot more complicated. I said you'd start to get a little bit of an insight as to why I enjoy practicing this area, and this really is where it comes into play. Employment law is a fascinating combination of contract law. Employment law is a contract and all of the principles that apply to that. Public law in the way that it is regulated by statute. Obviously, we've had elements of EU law historically, which have influenced how employment rights and specific parts of both UK and EU statute were interpreted, and discrimination law and all of those social issues that I was indicating before. And I think particularly during the 90s and into the early 2000s, it became apparent that employment law was an increasingly complicated area. This wasn't just training levy assessments done against some relatively simple criteria. It was becoming pay disputes, it was becoming holiday disputes, it was becoming fair or unfair dismissal once that was codified in the 1996 Act. And then, of course, more recently, it's become very big, weighty discrimination issues. And when you think about some of the discrimination cases that are dealt with, whether that's ones that you've been involved in or ones that you are aware of as reported or having been in the media, for a first instance court, and let's not forget the Employment Tribunal is just a first instance court where initial decisions are made. Judges, lawyers, the parties are arguing some very, very weighty issues. Just to put a couple of examples, the definition of a philosophical or religious belief, for example. Part of the test there is, does this belief warrant protection in a democratic society? That is a huge test to be putting on one individual or potentially three, the legally trained judge and the two lay members who you often get in tribunal cases. And so you can see that level of complication has extended so drastically simply because of a change in the type of work we're doing. And it's absolutely fair to say, certainly those of you who work on the coalface will know this, where do social issues crop up first? They crop up in the workplace and they crop up in schools. And that's very much true. The Employment Tribunal has certainly extended from this contract statute interpretation jurisdiction to dealing with very, very significant weighty issues around particularly discrimination and more recently, in particular on the reported cases, this overlap of individuals' right to identity versus religious belief. And so that is, in a nutshell, I suppose, the history of the Employment Tribunal and why it's become this slightly strange jurisdiction that we find ourselves working under today. It deals with so many different areas, so many different issues, and that is without even coming on to the emotional involvement that we obviously anticipate in employment cases. So what are our key areas in dispute? I've hinted at quite a few of them there. I'll run through them briefly here just with a very quick summary. I will talk about them all in more detail later in this morning's session. But I suppose in general order of how common and how frequent we see them, dismissal claims, of course, particularly unfair dismissals. Watch this space. I will not be doing a session on the Employment Rights Bill, but we do know fully well that unfair dismissal claims are going to change in the next 18 months or so. So do keep that one in mind at the moment. That will change, I think, to an extent how dismissal cases are handled. But of course, within dismissals, we are primarily talking about ordinary unfair dismissals, 2 years service, usually capability conduct issues, constructive dismissal claims, and automatically unfair dismissals. I put discrimination as kind of the second most common. There's an argument it's the first, but I think it's easier to think of it as split into the separate protected characteristics. But of course, discrimination, a big area of dispute in the Employment Tribunal. Any form of discrimination which takes place in the workplace that is due to one of those statutory protected characteristics is an issue that can be raised in the tribunal. It can be raised from day one. Indeed, of course, we know it can be raised even in respect of recruitment. Somebody doesn't need to be an employee to bring that claim. And indeed, they can also be self-employed. There are discrimination claims in relation to self-employment. Breach of contract and counterclaims I'll come back to in more detail, but again, this is about remembering that the employment contract is fundamentally a contract. It can be breached in certain ways. Significant changes to the contract are a breach. Constructive dismissal claims are a form of breach of contract, and there is jurisdiction within the Employment Tribunal for an employer to bring a counterclaim for breach of contract where an employee raises one. Again, more on that to follow as we roll through. And finally, the other big one, I suppose to an extent these are less common, but where they do crop up, they tend to be quite significant and wide-reaching issues. So you've got all of the various statutory claims, and these tend to be the ones that overlap with sort of breach of contract and dismissal issues. So where we're talking about the statutory claims that the Employment Tribunal has jurisdiction to hear, yes, unfair dismissal is a statutory claim, but I think we can sort of think of it as a separate concept. What we're talking about is things like working hours entitlement, so claims under the working time regulations, depending on sector, depending on role and the significance of those as well. Holiday entitlement, so again, thinking back to what I was just talking about with some of the complexities of the cases that the tribunal deals with. Most of us will be vaguely familiar with the Bear Scotland case, the rules on how holiday accrues, cases around rolled up holiday. These are all issues that are fundamentally, again, dealt with in a tribunal that's a court of first instance. I've mentioned whistleblowing claims. Again, I'll come back to those in more detail, but two specific claims there connected to whistleblowing, which the tribunal would have jurisdiction to hear, and all of the various family-friendly rights. Again, as I say, these kind of statutory claims, not ones you sort of generally see on a day-to-day basis. The most common stuff is almost certainly unfair dismissal claims, discrimination claims, as I know I talked about in a previous session. But where these statutory claims do come up, they tend to be quite big issues. Most employers are aware, particularly with these ones, because they're constantly guided about the rights to things like maternity leave and pay through their payroll provider. And it's unusual to get those wrong. But again, where it does happen, they are quite big claims and they can be quite complicated ones. As you know, in particular, we've seen historically with holiday claims. So moving on, where we are dealing with the Employment Tribunal and employment issues in general, it does always help to have some awareness. I'm not suggesting that everybody leaves this call and immediately goes and starts reading all of this legislation, it would take you a very long time. I can honestly say that most of us have not read all of it anyway. It tends to be fairly restricted provisions that we're interested in. But it is useful to have an awareness of what some of these are and where they come from. Savvy employees will do their research if you're in the middle of a process or procedure. And naturally, when you get to the employment tribunal, this is what is going to be being argued about, basically. So some of this legislation and some of the practical things to be aware of because of where they come from. Employment Rights Act, of course, I mentioned at the start of the session. Those are most of our basic fundamental employment rights, funnily enough. So this is unfair dismissal, contractual notice pay, definition of what does and doesn't amount to a fair dismissal. Constructive dismissal is implied in there as well. Various rights in relation to time off are connected to the Employment Rights Act, although they come in other places as well. And again, I said that this would not be a session on the Employment Rights Bill, but I can't not mention it. Yes, the Employment Rights Bill has made its way through the House of Commons. It is currently sat with the House of Lords. There is going to be a little bit of back and forth over it, inevitably. There always is between the two chambers. But based on usual timelines and how these things go through, and the fact that a government with a majority can generally find a way to get through what they want anyway, it could well be that the 2025 Employment Rights Bill becomes the 2025 Employment Rights Act later this summer. Now, I know there's been a lot of panic stuff going out about make sure you're ready, it's progressing through Parliament very, very quickly, blah, 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 blah. I'm not suggesting panic stations here, but I do think there needs to be an awareness of this. I think what we're probably going to see is some of the provisions rolled out over the next few months, over the next year, over the next 18 months potentially. And in reality, I think what we'll probably see is a repeat of the old April-October updates, slowly implementing things as we go. The only one I'm particularly concerned about at the moment for the purposes of today's session really would be the day one unfair dismissal rights. I think that's going to be one of the last things to be implemented. If we see anything come in this year, it's likely to be sort of the fire and rehire bans, I suppose in effect bans, I should say, and some of the proposed amendments of things like the Equality Act and maybe limitation periods. If you've got any interest in looking at the 2025 bill, and it's over 300 pages, so if you've got absolutely nothing better to do or are struggling to sleep, trust me, it will help. What you'll see is that it doesn't really set out any huge chunks of obvious legislation by itself. What it mostly does is amend the Employment Rights Act, the Equality Act, and a couple of other bits of legislation. Now, unhelpfully, what that means is the best way to understand the effect of that bill is to have both acts in front of you and be flicking through them to almost play spot the difference or slide in what it says in the 2025 bill into the other legislation. Two choices. You are, of course, more than welcome to do that yourself or wait for one of us to have inevitably done it because we need to. But yes, do be aware of this. Do be aware of the changes that are cropping up. We're deliberately not doing update on it at the moment because there doesn't really seem to be much benefit in doing that until we actually know what the final piece of legislation is going to be. I suspect it's very, very unlikely that there'll be huge practical changes that desperately need doing in August, for example. The other one to be hugely aware of, and I know most of us are, it's the one that causes the most panic, I think, for the majority of employers, is, of course, the Equality Act 2010. It has become this almost quasi-constitutional piece of legislation, I suppose, in that everything we do and think about, we almost feed back to the Equality Act now. So things to be aware of when you're thinking about the Equality Act. Make sure you know that list of protected characteristics and, more importantly, what they all basically mean. So that is the age, the race, the sex, the disability. They're all set out at the start of the legislation and then defined in more detail through sort of subsequent immediate sections, and a huge amount of bump at the back as well. So to use the example most of us are familiar with, we know Section 6 is the definition of disability, mental, physical impairment, long-term effect, etc. there's a lot more information about the test around that and what various phrases mean much later in the legislation. It is, if it's something you're dealing with all the time, absolutely worth being aware of. Other things obviously then drawn from the Equality Act, all the various forms of discrimination and what they mean. So direct, indirect, harassment, victimisation, duty to make reasonable adjustments, that's sort of sections 20, 21, 22. And helpfully, a mop-up provision for claimants, section 39, which tells us that we're not allowed to discriminate in offering, recruiting, the terms of employment, or the termination of it. A couple of others that I've just thrown in. National Minimum Wage Act does exactly what it says on the tin. Obviously, be aware of all of the current changes. No doubt your accountant and or payroll and or in-house finance officer has made you aware of these. National minimum wage is changing. We know national insurance changes as well at the same, or has changed, I should say, at the same time. So lots to be aware of there at the moment. Keep an eye on national minimum wage. I suspect that is going to be one that crops up a lot under the current government. Working time regulations, they're all the ones that talk about working hours, rest breaks, holiday entitlements, all of those sorts of things. The working time regulations, just to be absolutely clear on this, because it is a question that I had crop up recently. Yes, it implements the Working Time Directive, which was an EU law piece of legislation, but the working time regs are UK statute in their own right. Having left the EU made absolutely no difference to the wording of those regulations. It may change the interpretation in due course if the Supreme Court decides to overrule the ECJ final decision on something one day for whatever reason. But at the moment, yeah, there's no sort of drastic changes to that from what we've been used to. One quirky one that I have put on the bottom, and almost everybody who has dealt with an internal grievance, complaint, or indeed a possible legal claim will probably have had this crop up at some point. And it's where an employee uses a phrase like, oh, and you also breached my data protection rights. Now, the starting point is what I've said on the screen here. The Employment Tribunal does not have jurisdiction to hear what I've called a GDPR claim there. That's often the language claimants are using these days. It's just not within the various legislation that tells them what they can and can't deal with. The correct course of action for an employee who believes there's been a data protection breach is to report it to the ICO. They can bring a separate civil claim if there's been some kind of damages caused by leaking of sensitive data, for example, but it is not something that the tribunal can make an award for. That said, data protection breaches are not completely irrelevant in the Employment Tribunal. They can indicate a process or procedural failing, for example, by the organisation. They can amount to a breach of trust and confidence or build into a breach of trust and confidence for a constructive unfair dismissal claim. And it is also possible for a breach of data protection, maybe particularly where it refers to medical data, for example, to be an act of discrimination, presumably in relation to disability. I can see conceivably that it would be an act of harassment, unwanted conduct connected to the disability, causes the hostile, intimidating workplace. I can also see it being seen as an act of victimisation if there was any implication that the data breach happened deliberately in response to bringing a claim. So, yeah, tribunal doesn't have jurisdiction to hear a data protection breach. It can't make an award for it in isolation, but that doesn't mean we have to completely ignore it, obviously, and more widely we naturally want to be interested in data protection anyway because of the ICO's powers. So, a bit more detail on some of those claims and the types of situations where they arise. And I think this is important to talk through because this sort of sets the picture of what it is that the tribunal is dealing with on a day-to-day basis. And then I suppose more importantly, what we can do to make sure we're not the ones they're dealing with it. So when we're talking about unfair dismissal claims, this is primarily the ordinary unfair dismissal. So that is the employee who, under current law, has 2 years service and is dismissed. There's a lot more information on this for the recording that my entire team and I did last month, where we did an entire dedicated session on unfair dismissals. Those of you who are supposed to be coming to Chewton Glen, by the way, I apologise, that was not our fault. But if you want more detail on how ordinary unfair dismissals work, or indeed any type of unfair dismissal works in detail, do go back and watch that session. But for our purposes today, in kind of very brief overview, somebody who's got more than 2 years service is dismissed. They make broadly one of two arguments. Either you didn't establish a fair reason for dismissal. The Employment Rights Act tells us what they are. It's the person's capability, their conduct, it's the fact their role is redundant, it's become illegal to keep them employed in the current role for some reason, or you have some other substantial reason that justifies dismissal. If you can't establish one of those 5 reasons and the individual has got 2 years service, it's likely to be an unfair dismissal. The second part of that claim relates to process and procedure, and the question is ultimately, was the dismissal procedurally fair? The overall legal test here is, was it fair and reasonable in the circumstances to terminate that employee's employment for the reason that you said you did? And that's all investigation, process, reasonable decision making. With the test being, would another employer in the same circumstances have reached the same conclusion? A couple of other types of unfair dismissal to consider that do crop up all the time. I've mentioned it a couple of times during the session already. Constructive unfair dismissals. So a constructive dismissal ultimately considers the employment contract as a contract. If the employer acts in a way that appears to fundamentally breach that contract, or clearly intends to fundamentally breach that contract, an employee can resign in response to that breach and then claim that it was what we would call a repudiatory breach. You've acted in a way that suggested it was terminated. If that happens and the employee can show all of that, constructive unfair dismissal allows them to then make the argument that it's as if they were dismissed without reason. Constructive unfair dismissal claims can be quite difficult on a claimant. They do tend to take up a fair amount of time because of that couple of steps that they have to prove. Did the breach happen? Did I resign in response to it? And was it a serious enough breach that it justified me resigning? For that reason, constructive dismissals are, when you're advising a claimant, often kind of quite difficult to suggest they pursue. The final one with unfair dismissals really to be aware of is automatic unfair dismissal. So this is the various list of reasons, and there's loads of them, where if a tribunal concludes that as an employer, your primary motivation for a dismissal was one of these things, even if you've called it something fair otherwise, the dismissal can be deemed automatically unfair. Automatic unfair dismissals don't have service requirements, and they are designed to protect employees doing things like whistleblowing, public interest issues, or asserting one of their own rights, so perhaps in relation to health and safety, or asserting one of their various statutory rights to things like leave, pay slip, or even pay, actually, at a real basic level. So that's basically a very quick overview of unfair dismissal claims and the types of issues that the tribunal deals with. You can see where most of those would arise. Discrimination claims, again, most people on the call will be familiar with. So those protected characteristics that I was referring to when talking about the Equality Act a moment ago, important thing there to make sure you are familiar with those and what can trigger all of them, so to speak. When we're looking at discrimination claims, we're then talking, of course, about the ones that are set out in the Equality Act. So that is direct discrimination, treating somebody less favourably because of a protected characteristic. So not recruiting them, refusing a promotion, dismissing them because of their age, race, sex, disability. Indirect discrimination, again, do go back to the session I did on discrimination in full, but an indirect discrimination claim, very broadly speaking, you have a policy or practice in place that affects everybody, but it disproportionately and adversely affects somebody with a protected characteristic, and you can't objectively justify having that policy in place. The test ultimately there is, can you show that there was no less discriminatory way of achieving a legitimate outcome? So where we're often seeing indirect discrimination claims at the moment is usually in relation to flexible working, arising either from the issue of disability, where of course it can also be a reasonable adjustments issue, or sex indirect discrimination claims, where it's recognised simply that basically women have a greater obligation for childcare commitments, so you're more likely to be putting a woman in a problem by refusing a flexible working request, particularly if it's for childcare reasons. Other forms of discrimination, then, of course, harassment, victimisation, both allowed for and both commonly dealt with in the Employment Tribunal, and the one I mentioned a moment ago, sort of sections 20, 21, 22. Those are all of the discrimination claims connected to reasonable adjustments for somebody with a disability. Wages pay contract disputes, so money claims, ultimately the kind of thing that we sort of think about as court cases other than criminal. So this would be for things like non-payment of wages covering bonuses, any unpaid overtime that might be deemed contractual. So again, check your contracts, make sure it's clear on how overtime is paid and on what basis. Holiday pay claims fall under a combination of this and obviously sort of the Working Time Directive disputes. We know that holiday pay claims, as I was hinting at earlier, can get really quite complicated in the Employment Tribunal. A few changes, of course, to the legislation recently have made this a lot easier. 12.07% rolled up holiday. Whether they will change again in the course of this Parliament, of course, I don't know. It's worth pointing out that for claimants in particular, there is a limited value when it comes to contract claims. The Employment Tribunal has only got jurisdiction to award a contract dispute to the same value as the county court, so it's around £25,000. What you will occasionally see, therefore, is employees tend to steer clear of bringing a specific contract claim unless it's the only way to pursue the value they're looking for. So if they can tie it into an unfair dismissal, so for example, a non-payment of a contractual notice period, of course, is basically a contract claim. But if there's an unfair dismissal, they can tie that into and say it forms part of their loss. They're much more likely to do that knowing they've got that 115 that's just gone up, 120 odd £1,000 claim to work with, rather than try to pursue it as a contract claim. Partly because of the limited dispute value and partly because of a point I'll come on to in a moment. Whistleblowing claims, the other big one then, these are the ones that sort of can have that significant value in the same way as discrimination. Compensation for whistleblowing claims is broadly awarded on an injury to feelings basis. So make sure, again, policies, practices, procedures, etc. do help you identify when whistleblowing genuinely takes place, and then that there are appropriate protections in place for the whistleblower. So the whistleblowing claim comes under the Employment Rights Act, but it's linked to the Public Interest Disclosure Act, and they're pretty much cross-referred to each other. So there we are looking for things like genuine reporting of breaches of legal obligations, environmental damage, health and safety issues, all of those sorts of things, providing they're done in a certain way, providing they're done genuinely, there is a protection there. Just a key thing to point out with whistleblowing claims, the employee is allowed to be wrong. As long as they've got a genuine belief, it doesn't matter that they're wrong about the thing actually happening. Final one to mention then, collective claims. This is groups of employees bringing a related claim or having some kind of connected issue, multi-party type claims, and claims brought by trade unions on behalf of its members or a workforce collectively. The one of these I'm most familiar with at the moment from reading in the media is obviously the equal pay claim, so that's sort of the supermarket cases, and most of us will be familiar with the case involving Next that reached an outcome not too long ago. The one I'm personally involved in, more no jab, no job cases, and basically what the tribunal has done here is gone, we've got hundreds, if not thousands, of claims that are all basically about the same issue. Let's pull 20 of them, use them as test cases to decide the basic issue, and then throw it back out for the tribunals to individually deal with as they feel they need to. So the tribunal does have this quite broad power to dispose of claims in the way it seems most fit, to implement various forms of case management procedures, which we will come on to in next month's session in a little bit more detail, but that's a good example of the tribunal using kind of its own inherent powers to deal with things in the most efficient way to handle a collective claim. And what's basically going on with those, a lot of the claimants have said they were discriminated against because of their religion or belief. either because there was a religious reason they couldn't take the vaccine, or because they had a philosophical objection to taking the vaccine generally. And all the tribunal was doing is saying, look, we don't need to go to appeal level to do this. Let's make a first instance decision. Firstly, is that a legitimate protected belief? And secondly, even if it is, does it matter? Can an employer be responsible for dismissing somebody in that situation in a discrimination way, when what they've actually relied on is the fact that it was illegal to keep these people employed? So that's kind of an indication of how collective claims do crop up. So yeah, you can have kind of these massive multi-parties. Obviously, there's hundreds of claimants, hundreds of respondents in those cases, or similarly cases where you've got maybe 5, 6, 7 people claiming against the same respondent. So last bit of today's session, I did say I tried to finish early. I think I'll just about be there. None of this will be new to most of you, but it is absolutely worth me running through, simply because any one of these can be an underlying issue behind the thing that gives rise to an employment tribunal claim. So inevitably, we always say it: clear policies, clear procedures. It is important that all staff understand what the policies, procedures and rules are about anything they're going through in the workplace, but I've highlighted there particularly the ones conducting them. You know, it's all fine and good us understanding what the process and procedure is, but we're not always the manager who's running that individual process. Overlapping points, effective communication. What you'll often find is that a dispute has escalated quite rapidly because of a lack of communication or because of a lack of understanding between two individuals. And I think these two, maybe three, if I include training and awareness, can all fall under one overlapping point here. I don't think it's too controversial for me to say that a common place for issues to arise that ultimately end up in tribunal is a manager who has been promoted on merit but not given the people skills, not given the ability to manage a team effectively. And I do think that's a fairly common theme, particularly in unfair dismissal claims, where somebody gets stuck rigidly following process or procedure because they take the book in with them, they follow it because that's what they're told to do, but they don't understand the nuances of employment law, perhaps in the way they need to. So that training and awareness, yes, okay, it's of the process for the managers. It's also for them of how to have those conversations, particularly how to have difficult communications, and EDI and employment law more generally. If you've got somebody responsible for the rights of individual workers within their workforce, they need to know what those are, and they need to know, more importantly, the risks of getting it wrong. I've mentioned investigation procedures there. Yes, it's fine. We have the unfair dismissal process or procedural issues point. Investigation procedures do help to cut off a lot of those kind of claims if you can show that there's been a fair process, that it's been transparent. And that does mean, and again, this is something that seems to crop up in disciplinary conduct dismissals and investigations all the time, an unwillingness to look at exculpatory evidence. You know, if the employee is saying you need to interview Joe Bloggs because he knew I was in a different room at the time, there's absolutely no justification for not interviewing Joe Bloggs other than he doesn't want to. So it is important to consider evidence from both sides of the story. Some of the worst and most easily torn apart disciplinary investigations are the ones that don't do that. Fair recruitment practices. Yeah, recruitment claims are quite rare. It is really only discrimination where that's going to crop up anyway. But I think the importance of having this sort of fair, transparent and well-managed, well-governed recruitment process actually sets you well in store for the rest of your procedures and processes. You might as well be getting it right from the start, because there's clear indication here that if we're not doing step 1 well, why on earth can we assume that we're doing step 2, step 3, step 4 well? So I do think that is one that's definitely worth having in mind, definitely worth considering. And then finally, kind of moving on to I suppose process and procedure more generally and what some of those should look like. Yes, capability can be a fair reason for dismissal, but again, only on the back of meaningful, effective and engaging performance management processes. The starting point with a performance-based dismissal, whatever the reason behind it, is actually get this person back up to performance. So one of the most common issues you see in performance-related dismissals making their way to tribunal is the intention from day one was just to get rid of me. It was a performance management process that was orchestrated to see me leave the business. And where those claims are well sort of formatted, well constructed, they can be quite difficult to defend if you've not had that effective process throughout. Similarly with internal complaints, grievances, don't forget the ACAS Code of Conduct applies to grievances. That's one that people sometimes do miss. They should be effective, they should be transparent. And again, where claims arise from those, they often start to build into constructive dismissals, or somebody misses a discrimination allegation when it comes to a grievance. And again, that's why it's important to ensure that managers handling this process know how to identify something that could throw up a red flag because it's discrimination, because it's whistleblowing. And again, similar point when it comes to general consultation, when it comes to training, so consultation on change of terms, consultation on redundancy, consultation on TUPE. Some of those require much more significant knowledge of the law and the expectations than others. So make sure whoever is conducting those conversations knows how to spot potential issues, knows what those red flags are. When it comes to training processes, I mean, there is a difference between performance management and daily management. There's nothing wrong with implementing effective daily, informal, weekly, whatever, informal management to ensure somebody is working to their most effective level that falls short of formal performance management. But they're not a substitute for each other. So again, that comes back to having that policy, having those procedures in place to make sure that whatever system is being followed here is one that ticks all of the boxes. There we go. I said I'd run slightly short, and I have, so I'm just about there. Last few practical tips for you just to be aware of. As an employer, always know your obligations. Keep an eye on the law, keep an eye on the updates. I know a lot is going to be changing this year. We will try to keep you updated as much as possible. As and when there is something to significantly update on, I may well do a dedicated session outside of the normal scheme if that would be helpful. Trying to avoid employment tribunal, always consider mediation if it's an option internally. There's no way we can force somebody to engage in mediation, but it is remarkable what personal issues a mediation can resolve, along with all other forms of dispute resolution. As I said there, and as I was hinting even more clearly a moment ago, the law does change constantly. It's why I love this area, it's why I hate this area. The definition, things that can be considered a disability one day might not be a next, and it all depends on the individual, it all depends on the personal circumstances. There is no one size fits all because we're dealing with people. Last bullet point there, that's a verb, not a noun. It's document, document, document. To be honest, when you get to the employment tribunal, claims can sometimes be decided based entirely on what an employer can show they've thought about at the time. A few that stick out are things like automatic unfair whistleblowing claims, because the decision maker was aware that somebody was a whistleblower or potentially wasn't aware that they were a whistleblower, can be fairly determinative here. It is always worth, to be honest, document things. It is generally safer. You know you're not going to put anything ridiculous down on a document that you shouldn't be writing down, but if your justification for terminating somebody is based on their performance connected to a third-party complaint, connected to issues you're receiving internally, document it all. That is going to help when inevitably they say later down the line, you can't prove that, or no, it's because of my disability. Show your thought process more than anything else, especially in making a dismissal decision. And that is me done. I've noticed a lack of questions, which either means nobody was listening or I've covered everything I felt I need to. As I said, today's session was always intended to be that very sort of high level overview of introducing the employment tribunal and the kind of things that crop up in it. The next session will be on Wednesday, the 14th of May, because I finally decided to have a week off this year, so I won't be around on the 7th. We'll be looking at the actual employment tribunal as a procedural process, as the hearing churns out and all of those sorts of things. So I'll be talking about the filing and response of the claim. We'll touch on deadlines. We'll be talking about case management preliminary hearings, but the majority of that session will be on what actually happens at the hearing itself. I'm hoping one of my colleagues will be able to join me for that one so that you get to hear two voices, two different perspectives, and ideally I'll try to drag in one of them who has actually been a witness, and we'll have a little bit of a conversation around that as well. I've put outcomes and next steps. That will probably roll into the June session. So apart from that, unless anybody has got any questions that I can answer about what I've talked about so far, I will let you go get on with your days, and presumably for some of you, your financial year end. Enjoy the rest of your day, enjoy the rest of your month, and I will see you all hopefully on Wednesday the 14th of May. If there are any general questions, I'm happy to hang around for a few minutes and take a look at those, but otherwise, thank you everybody.